national social media. Patel Prahalad Bhai.
Lord, sir, the short point is this.
Check this out. I'm going to show you how I afforded this car. Okay.
There are two separate regimes in Singapore. One permits modification, one does not permit modification. Our fortune or misfortune is that in our part one of our...
One specifically bans modification, one impliedly bans modification.
My Lord, one doesn't specifically ban modification. My Lord, your Lordship is reading 47. In fact, 48, 49 permits the modification. 47 has to be read with 48, 49, 50. It is not an express bar. It is as except, then gives 3 grounds for modification and a PV, which, my Lord, we should actually have here. We should have a wider scope of challenge in our Indian situation. It's another matter. So, my Lord, the International Arbitration Act does not contemplate modification, is what the judgment says there. Now, my Lord, our act has this, sorry to say, khichdi. My Lord, our act is, and I agree with Mr. Datar, my Lord, we have copied, cut and pasted ICA law into our domestic act. For whatever reasons happened in 95, my Lord, your Lordship may know, I have some idea as to why it happened. It has happened. Now, our act, if your Lordship just sees the act, covers both in part one. So part one covers a situation of an international commercial arbitration as also other than international commercial arbitration. So sometimes, you know, there's some confusion between domestic foreign. If the arbitration is seated, let us say in Delhi, it could be other than, which is purely domestic, or it could be an ICA. That is clear, my Lord, from 21F, and that is also clear from section 34. Now, if that be the case, my Lord, 34 will apply, subject to 2A, will apply insofar as ICA is concerned. Now the question which comes is, can an ICA award delivered in Delhi, may I put it differently, ought an ICA award delivered in Delhi be subject to modification? That's, my Lord, one question which squarely arises. Whether a domestic award should be subject to the amendment, my Lord, I'll come to. So let us take a case, my Lord, supposing your Lordship do not accept the argument and say, yes, an arbitration under 34.1, my Lord, 34.1 setting aside includes modification. And supposing, my Lord, an award such as an ICA is modified, what is the practical and legal consequence? I will, my Lord, demonstrate, and I put it in my note clearly. My Lord, such an example is there before my Lords in the Vedanta matter. In Vedanta, my Lord, it was a foreign party, Chinese party, against Vedanta. The award was upheld by single judge. Award was upheld by division bench of Delhi High Court. The Supreme Court tweaked the interest. There was some portion where the interest was tweaked. For whatever power, my Lord, I'm not going on the power. Now, my Lord, the foreign party, there is a problem here. There is a problem, my Lord, in the Delhi High Court execution. There have already been 3 rounds as to how much of the award has been modified by the judgment. That's a separate point. Now, my Lord, hypothetically, please take that award. That's an ICA award made in India. Take that award and try and enforce it against Vedanta in London. My lord, it will fail on a very simple point. It will fail because what are you enforcing? Are you enforcing the award? No problem. There's a judgment. Are you enforcing the judgment or are you enforcing the award is modified by the judgment? My lord, this is a problem which is being statutorily addressed by at least 3 jurisdictions because this is an international problem. And they have brought in specific statutory provision to get over this. So, moment your lordships judicially agree that an ICA has to be modified, it will cease to be enforceable under the New York Convention absent the requisite backup legislation. So that will be the inevitable consequence. So therefore, Manoj, the question of having ICAs in India will go because the main benefit of the New York Convention of enforcement abroad, an Indian party may want to enforce abroad, this may have been a foreign party, will go. And my lord, 3 sections.
So suppose 34,
So,
4A is applied and there is a severance.
my lord,
In
30,
the ICA,
2
International
A's
Commercial Arbitration, India seated,
severed,
award passed,
severed.
severed under the non-arbitrability clause. We'll just go to that, 34.
No problem, my lord.
That award
That's
also
just,
will have the
that
same
portion is set aside, it cannot be enforced.
that award will also.
Because of my lord 5(2)(e), that portion of the award cannot be enforced because of 5(2)(e). No difficulty.
No, if that is so, if in the form of interest, which doesn't affect the integrality of the
My
award,
lord, I will show 3 provisions of 3 acts.
does in any way impinge on your contentions, evidence. It is a 31(7) power, exercised by the arbitrator.
Let us take that example. I am grateful.
That will be a money added to the awarded money.
Let us take that example. My lord, exact example in Vedanta. Please take that example. The matter comes up, it's an ICA, award has been modified. My lord, award has been modified on what basis? Patent illegality is not available. So it will have to be public policy, or it may be, my lord, 142, whatever. Award is modified. Now let's not question why the award is modified or award is modified. Now I take that award as modified to enforce it. Now, my lord, there are 3 provisions which I want to show to my lords, which are required under our statute to make sure. So, my lord, modification has to be legislatively brought in and modification has to be legislatively protected. Please see the provision, my lord. The learned solicitor has put it in his compilation. I'll show 3 of them immediately. First, your lordship will see 289 in England.
I can't get hard, not even with the blue pills.
There are specific provisions which deal with this problem. Today, by judicially modifying an award, you will render the enforceability of any ICA vulnerable outside India. Nobody will bother coming to arbitrate ICA disputes in a Delhi seat or a Bombay seat because they will not be comfortable knowing that it cannot be enforced. That's the submission. Please see 71. India seat. So you will have a situation inevitably where your ICA is inconsistent with the international.
Is it as far as Singapore you have pointed out?
No, I am not on Singapore. I am on here.
1 minute, please.
Please see 71.
1 minute, please. As far as Singapore is concerned, also, as far as domestic arbitration is concerned, if the seat is of arbitration is in Singapore, domestic will apply or then international will apply? If the seat is in Singapore,
International will apply if it's an international arbitration.
but even if involving a,
Both are, yes,
even if one party is a Singapore party,
yes, my lord.
right?
One part,
But
yes, same here.
1 minute, please. But as far as, say in a given case, in England, where the domestic law makes a variation possible,
Yes,
it will equally apply to foreign arbitrations,
yes, madam.
correct? Because the law of arbitration may be
It will apply to an ICA. Let us say ICA.
The law of arbitration
Yes.
may be that of England.
No dispute.
In that case, will you say the same logic will apply? Your argument? that
Yes,
the
yes,
law
the
will
same
not-
logic will apply and the reason to get over that.
Therefore, your reasoning that in case we interpret it this way, it will defeat or it will negate it will make India an unattractive arbitration destination is flawed. Or if that is so, then Britain will not be a favored.
Short reply. England, your lordship has taken the case of England. 71(2) has been specifically enacted to get over this problem. My lord, there are specific provisions which deem an judgment to be an award. There are problems with that. There are deeming fictions which have been brought in by statute to protect such a modification. That is not there.
In case of international law arbitration.
Yes, they have. Please see first 71(2). I want to show my lord 2 or 3 other provisions. So, my lord, even clearer. England has 71(2) where the award is varied. The variation has.
Which page are you on?
289 of volume 4. There are specific provisions which rescues this problem.
Okay. Yes.
71(2), my lord, where the order is varied, the variation has effect as part of the tribunal's award. So it is deemed to be part of the tribunal's award. My lord, even more clear provision, and I'm grateful, my lord, to the learned solicitor to have pointed it out, is in his written submissions. Page 28. Page 28 at 29, New Zealand. 28, New Zealand, 28, section 5(7), where the award of an arbitral tribunal is varied on an appeal under this clause, the award as varied shall have effect except for the purpose of this clause, as if it was the award of the arbitral tribunal, and the party relying on the award or applying for its enforcement under Article so-and-so shall supply the duly authenticated original order of the High Court, varying the award of the duly. Your Lordship knows under the New York Convention, you have to supply a certified copy of the award. So,
but then will the same principle not apply in case the award is segregated? In case the award is segregated and portion of the award is set aside? Same
if it is set aside, that cannot be enforced.
So, if
the balance
with to that extent, the award which is modified cannot be then applied abroad?
Because, my lord, there is a defense. I'm sorry, my lord. There is a defense under 5(1)(e) of the New York Convention, which says when part of an award is set aside, you can object. So, my lord, it's a defense. What your lordship is saying, partial alignment. My lord, one part is set aside. I file my award. The other side, in 5(1)(e) will say defense, that by the way, this portion cannot be enforced in England because it has been set aside by the state court. So, my lord, there is an inbuilt remedy in the New York Convention. Today, if your lordships are going to modify, say, interest, the consequence is serious. My lord, there are, I can produce, my lord, live examples. I didn't realize this was, that there will be serious problem of enforceability of an IC. That's the reality, my lord. And that is why, if we wish to do it, and maybe we should, my lord, if we wish to do it, we should do it through carefully calibrated, targeted legislation to make sure that our award is enforceable.
It's so difficult to manage, Mr.
Sorry, madam?
It's not that difficult. You see, even in part 2,
No, we are not in part 2.
I'm just taking for example. Suppose there is an enforcement proceeding. The party says in receipt there is a challenge.
Yes,
There is a power to give security and have the matter adjourned.
5-2.
By 48(3)(a).
5-2.
Now,
Same.
now, suppose the award proceedings result in modification of interest.
Correct.
What is the difficulty for the enforcing court?
One of the enforcement court will say, as it has said, it's not an award. This is the standard defense will be. It's not an award. It's an award modified by a judge. Until you have that legislative fiction which says that the judgment is deemed to be an award, it's a judgment. It is good enough to resist. It is good enough to resist. You are not enforcing, under the New York Convention, you are enforcing an award for which you have to, under even our provision, give a certified copy of the arbitration agreement and a certified copy of the award. That's it. Now you are giving certified copy of the agreement, certified copy of the award, and the judgment modified.
Chief Justice's query on severance,
Sorry, Manoj?
severance matters.
Manoj, severance is very, very simple, Manoj. I am putting in the award. The defense is available under under Manoj section 48. The defense is available that that part of the award has been set aside. So I go with my award, I go with my full award, but the other side, other country will not recognize the full award because the other party will put up a legitimate defense. So at that stage, the defense will be put up that that part is gone, annulled, set aside. Don't even look at it. So, my lord, there are practical difficulties which have across the board repercussions when this tweaking takes place. And while there may be good reason to do it, my lord, this may not be the forum to do it. That's all we are saying. We are not saying that this should not be done. I was part of that Vishwanathan committee. We also recommended that something should be done. That's a call. So this is one aspect I wanted to bring to your lordship's notice, that this is a live problem which will arise in ICA. And our further misfortune is, my lord, that if we read modification only in 2A, that is why Mr. Khambata was trying to restrict modification, perhaps restrict modification only to 2A. The problem is 2A is a ground, whereas the actual source of the power which we are trying to read is section 36(1). So you can't say setting aside includes modification for domestic, but setting aside does not include modification for ICA. There are difficulties there, Mulad. There are difficulties, and Mulad, to do a great right, one does a little wrong is also a little problem. So, Mulad, this is my submission so far as the second proposition as to reading it. Now, Mulad, I go back to the first proposition, because I'll finish in Mulad 10 minutes. I go back to the first proposition. The first proposition is that it is a good idea that this court should step in and short-circuit the process. After all, your lordships are there to do justice. So let's short-circuit. Apart from the fact whether it is to be short-circuited or whether that will itself involve another long circuit, one is not on that. But my lord, what is very interesting is two things. One is, what is that guideline and what it will be legislated, what is the test to be formulated? Everybody on the other side is given a different test. So we don't know what the test is. And everybody will give a test aligned to, my lord, their particular facts of the case. But be that as it may, my lord, I just want to end by citing two important judgments. The rest I have, my lord, put in my note. I am not going to trouble your lordships. My lord, this exact issue of policy came up in a very famous case under the 1940 Act. Your lordships will recollect that under the 1940 Act, there was no express power that reasons had to be given. Lordship recollects under that. And the matter went to the Law Commission. The Law Commission gave a particular recommendation. The learned solicitors read out the recommendation. The matter then went to a constitution bench. And the constitution bench affirmed what the Law Commission's recommendation said and kept its hands off. Even though, my lord, according to me, that's a much better case. That's a much better case that you ordinarily should have reasons in an award. I mean, after all, even on such a compelling argument, why did the court not interfere? And what were the policy reasons that weighed with the court saying, I am not going to touch it now, let the legislature look at it. Legislature did look at it, and we have the new act where reasons are required. So, my lord, I want to show 4 or 5 paragraphs from Justice Venkataramaya's judgment in Raipur Development. Just 3-4 paragraphs. You know, this is in volume 3, 1722. I put it in my note. I'll just read it. Your lordships will understand where I'm coming from.
Argued in this court, Mr. Banerjee, Mr. Nariman and Mr. Swarabji.
Yes, Mr. Nariman, correct. And I think the Solicitor General was
Yeah, well.
The dark spot facts you
2-2, Malone. Just 4 or 5 paragraphs, Malone. First, your lordship will look at paragraph 20 and 21. Justice Venkatramaya fully, Malone, analyzes the scope of challenge under the old act, and then he comes to paragraph 20, which your lordship will find at 1737.
Yes.
The Law Commission of India, however, had occasion to consider the question whether it should be made obligatory on the part of the arbitrator umpire to give reasons in support of the award. In the course of its 76th report on Arbitration Act 1940, submitted in 78. Well, the entire portion as to the reasoning is being set out, but I want to just, the entire portion is very instructive, but in the interest of time, your lordship will come to 4.45 or page 1738. There are, it seems to us, several considerations that are relevant in determining the question whether the arbitrator should be required by law to give reasons to the award. And my lord, various comments are made. I'm not reading that. Please come to 4.4.7.
Yes.
The previous experience, in fact, points out that these awards incorporating reasons which have generally been quashed, the awards not giving reasons have survived the attack.
That was, I'll be very frank, when we joined practice, that was the reason given by most arbitrators. Why they don't give reasons. Because the moment you give reasons, we are unable to challenge. But that had its own impact. But that had its own impact. That was the main ground which many of the most arbitration awards in the 70s, 80s, and before the 1996 award was passed. One line.
Now, my lord, the reason.
It was impossible for you to challenge.
Yes, the reason given. Why was
that was the wrong era.
The reason.
Party should not know the reasons why it was.
I'm saying, what were the policy reasons for coming to such a conclusion? My lord, the policy reasons was that the arbitrator, if honest, could be wrong, and two, that finality was something that was to be.
Mr. Banerjee, I think that was a mindset, and rightly so, because there were doubts expressed about arbitration, the efficacy of arbitration as an equitable and as fair a mode and as just a mode as court adjudication, therefore we should take up us.
Lord,
unless the parties
we come back, Lord, to the point.
Based on that, there is no question.
Come back, Lord, to the point.
Don't leave that judgment.
Sorry?
They made an exception for
public sector. I know. I understand all. But, my lord, the point is this. Two policy reasons why your lordship should not exercise a modification power are: one, party autonomy, and two, finality. The moment that exercise is carried out by the court, A, you go to a court whereas you wanted to go to a tribunal. B, finality is thrown to the winds because the arbitral award would be the round of 16. Then you have a quarter-final in 34, semi-final in 35, final in Supreme Court. And it would, that is, so two policies.
This argument is equally applicable in the state when the legislature amends it, except to the extent, because if the legislature amends it, the argument will be the same. You'll have a round of quarterfinals, finals, and then
I think, Lord, the reason it should be left is
the
legislature
other argument of yours that if they have repercussions as far as the enforceability of the laws or awards made in India, is something which is to be considered. We'll put it into others.
Lord, last one line, Lord. I just want to make a couple of points, and Lord, then I will conclude. Lord, there are three different, if I can understand, Lord, concentric spheres where we are concerned on challenge. One is that this is to answer Justice Vishwanathan's question. One of the narrowest sphere is the correct result. The correct result can only be within a narrow sphere. The slightly wider sphere is where there is an incorrect result as a result of misappreciation of evidence, or wrongful application of the law, my lord, that is specifically provided in section 34. The largest sphere where the court will certainly step in is something beyond 1 and 2 and go to 3, whether it is patent illegality, whether it is a problem regarding the process. After having got to 3 and found that 3 is a problem, then to modify, your lordships are skipping 2 and coming to 1. So the interest example, my lord, which seems to resonate through the court. No? The interest example is very interesting. The party who has lost on liability.
Homeowners, how many of you have seen?
One party has won on liability. The party who has won on liability may have lost 4 other claims on liability. That cannot be okay. The party who has lost on liability comes and says, please modulate the interest. The party who has won on liability can equally say, this means you don't trust the tribunal. The error that he committed on liability cannot be looked at in 34. It is a wrong view. I should have my day in court, and when it goes back and there is a set aside or annulment, all these issues are open, subject, as your lordship said, to res judicata, etc., limitation. My lord, there's a very nice judgment of the Court of Appeal of Sundaresh Menon. So, my lord, court is, moment it gets to that stage, it is, my lord, killing the snake without breaking the bamboo. It's that thin line where you don't look at the merits, but you correct the award. No, that's covered by 33. Or you find as a curable defect, that's covered by 34.4. So where is that other case, with due respect to all the various examples given by my learned friends, where is that third case where you pull out some inherent power and say, I'll tweak it? Where is that case without disturbing the merits?
What is the position on res judicata? 4 claims, 3 claims.
Res judicata, I'll answer it simply. There is the judgment of Justice Menon, which we have put in on res judicata, where he explains what is the consequence of setting aside. So, for instance, consequence of setting aside is you go back to an arbitration. It may not go back to an arbitration, supposing the clause is void, supposing it is non-arbitrable. Then you go to suit. Subject to limitation, that is answered by 43. Subject to res judicata, if you already decided something, then that binds these. So all this has been looked at and dealt with. So, my lord,
So 3 claims attain finality. If the 4th one is set aside, if the award is set aside with specific finding,
on 4,
then 4 alone will be open for.
only open. And that's the
Even we have held that KV George or something.
Yes, my lord. And this the other the judgment I am referring to is mentioned in my note is AKN versus ALC, also in the London Solicitor's Note, 2015 Singapore Court of Appeal 63.
If res judicata applies, then what is the problem? There is no problem of injustice there.
My lord, this is the issue. This is the, my lord, desire to do justice and step into the arena from being the umpire to becoming the player. The umpire is always better than the player.
Mr. Vinay, you're accepting it can be done, but you say that it should be legislative mandate because we have.
I am
Make
not
it
accepting
can be done.
My view is it should be done.
You are accepting, not only you are accepting it should be done, you are also accepting it is done in some jurisdictions. But you say it should not be done by the court, but it should be done by the legislature.
It will cause, my lord, enormous difficulty.
And the difficulty part is difficult to accept, except to the extent of international award.
My lord,
Probably in
unfortunately,
case
we
the
don't have
objection
to act.
taken is, in case the objection taken is, because it's not an award, now it's a judgment of the court, and therefore the enforceability part will have to be dealt with differently.
My lord, the thinking, I go back, my lord, to the Redfern portion. It is, the arbitration is not meant to be the first step in the process. That is how we are now thinking about it. Then, my lord, actually, I am with the solicitor. My lord, then if you want a full-fledged hearing and you want a full-fledged,
No, that's not the point. That argument doesn't. to be very frank, not too much ice for the simple reason that interference of the court will be still limited to the grounds stated in 34.
My lord, if your lordship
And
limited to
if the court musters the award, it cannot be, is not affected by any of the grounds of 34. There is no question of the court interfering.
Let us say first clear the hoop of 34(1), find some patent illegality,
Right.
then cure it then and there rather than sending it back. This is
That's
all. No, that is not the test which is being proposed.
no, that was the case. Let me put it. No, that,
Let me put it aside, my lord.
no, except for,
There's a question of will there be additional evidence?
no, this,
Will there be no additional
already specified in court. It can be recorded, but let us put it. We are not even going into that stage. This is what I said.
Because your lordships will be answering the question as to whether, assuming your lordships hold that power is there, then everybody agrees on the other side that it cannot be untouched.
You do that to us.
My lord, I think, my lord, I would end by saying this, my lord. I would mention, my lord, Justice Narasimha's comment, my lord, that we are overthinking this matter.
We are
really overthinking.
Let me put it.
Please set aside and let's stop there, my lord. We are not here, my lord, the court is not here, my lord, this is not a normal case. The court here is not to fix the problem. This is not the normal case where the court fixes the problem. It is not the court for the court to fix the problem. And that the entire purpose of arbitration is to step outside. If your lordships volunteer to fix the problem, your lordships will get more problems to fix. And that is the inevitable consequence. Well, I would only say,
Okay,
yes, deeply.
yes.
I'm sorry.
I want to buy your.
My lord, I beg to appear for IRCON, my lord, in IA 15336 of 2021, my lord. My lord, my submission, my lord, is twofold, my lord. I'll just at the outset say what my position is, and then I will give the theoretical basis of my position, my lord. My lord, in all probability, I will finish in less than 25 minutes, maybe 20 minutes, my lord. My lord, my position is, my submission for your lordship's consideration is that Section 34 of the Arbitration Act, as it currently stands, based on a correct interpretation of the section, court lacks the jurisdiction and power to modify or vary the award. That is my position, my lord. But it has the power to set aside a part of the award. So partial setting aside is permissible within the scope of Section 34, and I will read from the provisions to show how that is possible. But full modification is not possible. My lord, may I just hand over a note, my lord? It will help me just go through everything very quickly, my lord. My propositions are here, my lord. I have just two propositions, my lord. As part of these propositions, my lord, a subsidiary, as part of this stand, my lord, I will also take